Hi everyone, my name is Kate Dewhirst. I am a health lawyer and one of my areas of focus is privacy. So today we are going to do a privacy update for regulated health professionals. Just as a reminder, this is not legal advice. This information is being provided to you for general information purposes only. If you do need advice, please speak with your college, please speak with your professional association, or you can speak with a lawyer of your choosing. In this session, we want to give you a power-packed session on privacy. We want to cover 5 main areas: the role of health information custodians, talking about circle of care and what that might mean in your practice. Privacy and social media. There have been some new cases coming out dealing with the impact of clinicians using social media. There's some cautionary tales for you to know. The fourth topic will be talking about privacy and how you may need to deal with situations involving dueling parents, when there may be conflicts between children and parents and sharing information. And then we'll end with talking about privacy breach identification. There are lots of handouts for today that will be made available to you on the website. These slides, as well as a privacy prescription. So again, this isn't legal advice, but it just gives you an overview of the basic steps for you to take if you are a health information custodian to be compliant with our health privacy legislation. There's also a summary of the Information and Privacy Commissioner's decisions in health privacy in Ontario. And there's a resource from the Ontario Caregiver Organization, frequently asked questions regarding children and youth and privacy and consent. So let's get started. Let's talk about the role of health information custodians. One thing you need to know as a regulated health practitioner is when you're working in practice, are you a health information custodian, also known as a HIC, or are you an agent? So health information custodians are identified in our privacy legislation. That is the Personal Health Information Protection Act. And we've had that legislation since 2004. So we're almost coming up to the 20th anniversary of our privacy rules in Ontario. The law gives us a list of who is a health information custodian. And on the list are the usual suspects of organizations and individuals who provide traditional healthcare in Ontario. So you, as regulated health professionals, are right at the top. Healthcare practitioners, if you have your own practice, you are a health information custodian. There are also custodians for hospitals, psychiatric facilities, birth centers can be health information custodians, long-term care homes, the community health centers, family health teams, they can all be health information custodians. So the key thing for you to determine, if you have your own practice, then you are a health information custodian. If you work in a group, you may have to make a decision with your colleagues in the group, who is the custodian? Will you be collectively acting as a custodian, or will you individually be acting as health information custodians? If you're employed, for the most part, you will be an agent. You won't be responsible for setting the rules. You'll be responsible for following the rules of your employer. So that would apply if you are employed at a hospital, a family health team, a birth center, any kind of corporation, or a community health center. You're likely an agent. And again, that means that you don't make the rules about privacy. You follow the rules that your employer sets about privacy. So when we were designing this webinar, one of the things that the colleges wanted to make sure that we were clear on are the responsibilities if you are your own health information custodian. This is not an exhaustive list, but there are 13 basic things that you need to do. When you look at the handout, it says 14 because number 1 step is to determine if you are a health information custodian. But otherwise, there are 13 activities that you want to turn your mind to, you want to make sure are being done. If not by you, then who? To whom have you delegated these activities? So number one, you want to choose a privacy contact person, sometimes known as a privacy officer. That person will be responsible to respond to access and correction requests, respond to inquiries about your information practices, receive privacy complaints, and ensure that the team, the practice is complying with the Personal Health Information Protection Act. So whenever you see the acronym PHIPAA, that stands for our legislation, the Personal Health Information Protection Act. So that's step number one. Step number two is making records available to clients. All of your clients have a right of access. That means to view or have a copy of the health records you make about them. That's subject to some exceptions, but the general rule is that you, when requested to do so, you have to give a copy of or make available for viewing any records of personal health information that you make about clients. So a third responsibility is to have key, clear rules about privacy, usually in the form of a policy. If you look at the handout, there are some listed topics that you want to cover in those policies about safeguards, about consent, about privacy breach protocols, about dealing with access and correction requests and requests for release of information to third parties. Also dealing with consent directives. So make sure that you have written policies and practices. If it's just you, they don't have to be in writing per se, but if you have a team or a practice where you are sharing your records with other people, you want to make sure that you as the custodian are clear about the expectations of those activities in your health records. Number four is to make sure that anyone who is doing work in your health records on your behalf is informed about the legislation, informed about privacy, and informed about the duties to protect and take certain precautions in health records. There are general expectations that you are engaged in training on an annual basis with your team. Agents would include your staff if you employ anyone. You may be working with students. They could be your agents. You may have locum folks who are replacing you from time to time. And you may have vendors that you have hired to do work for you. So any of those groups can be your agents. They're doing work in health records on your behalf. And then there is an expectation that you're training them, keeping them up to date about what the privacy rules are, and that you're asking them to sign confidentiality pledges on an annual basis. There's another responsibility to have a written statement available to the public. Anyone who asks you about your practice, what are your information management practices? And when you look at the handout, there are some free resources available to you through the Privacy Commissioner for that. Keeping going in these 13 key health information custodian responsibilities, number 6 is what we often think about when it comes to privacy are having safeguards. It is your responsibility as a health information custodian to protect your health records and any personal health information. When you see the acronym PHI, that stands for personal health information, that could be in paper, that could be electronic, it could be your traditional chart, it could be your email system if you happen to have emails that come in with health information in them. You have to protect all personal health information that you hold against loss, theft, unauthorized access, use, disclosure, unauthorized copying, modification, or disposal. We often hear about safeguards covering 3 different types of safeguards. So technical, physical, and administrative safeguards. And there is an expectation that you have those in place and that you're auditing and doing privacy impact assessments and threat risk assessments. Number 7, you need to make sure that your records are retained, transferred, and disposed of in a secure manner. And one of the things that I would recommend is that you review your college standards for retention periods. Every college has an expectation, and your legislation may have an expectation for how long you keep your health records relating to your practice and your clients. Number 8, you have to ensure that there are appropriate content in any agreements that you have with vendors. These might be vendors for your electronic health record, might be software that you use for your work, may be related to shredding, may be related to cleaning services that come into your environment. You want to make sure that those contracts have the right language to ensure privacy, again, related to the health records and personal health information you hold about your clients. Number 9, you need to be doing audits of your electronic health records. And in a minute, I'm going to share with you, there are some new standards developing in this regard. There is an expectation from our privacy commissioner that you are auditing your practices. So those, again, your physical, your technical, and your administrative safeguards, but there are specific changing standards with respect to conducting audits in your electronic health records. So those are changing standards that are coming in 2023. Number 10 is to ensure that any new information systems that you put in place in your practice are complying with the digital asset interoperability standards that are set by Ontario Health. Does that sound confusing? Yeah, but maybe you want to delegate that to your information technology support people. Anytime you're going to have a new electronic health record, anytime you're going to introduce some new tech that's going to improve your work with respect to patients or clients, you want to be thinking about making sure that that technology is compliant with new standards. And there are some online resources for verified and validated technology that Ontario Health has already put through the ringer that already meets these interoperability standards. So either you have to go and make sure that that tech is listed there, or your information technology folks can do that for you. Number 11, you want to notify impacted individuals if you've had a privacy breach. So if personal health information has been stolen, lost, or accessed by an unauthorized person or disclosed to an unauthorized person, you must notify any impacted clients. Number 12, you need to complete annual statistical reporting to the Information and Privacy Commissioner of Ontario. If you've had certain kinds of privacy breaches, that triggers you to fill in an annual statistical report. I'll talk about that later in this webinar. Also, number 13 would be to get insurance. It is responsible of you as a regulated health practitioner to protect yourself and your practice, specifically from cyber risk. We're not going to talk a lot about that today, but there is an explosion, it seems, of ransomware, malware attacks. These are external attacks into electronic health record systems, and there is an expectation that you are keeping up with the technological or the technical safeguards to protect against that. But if it happens that something infiltrates your system, you are going to want to have insurance to protect yourself and your practice. So those are the basic 13 things for you to be thinking about as a health information custodian. You may have heard that there have been updates to our Personal Health Information Protection Act in the last couple of years, and those updates have increased compliance expectations. So I just wanted to highlight a few of those for you, because you may have felt like, there seems to be more focus on privacy in the last few years. There has been a new, renewed focus on privacy, even in the pandemic. At the beginning of 2020, there was really, as everybody had to go into virtual care, there was kind of an acknowledgement of do your best, connect with clients, but In the aftermath of the beginning of the pandemic, after a few months have passed, we see this resurgence of concern about privacy, and also reflected in the law and in compliance expectations. So I just wanted to alert you to a few things that have been changing over the last couple of years. There is a requirement, as I mentioned, for annual statistical reporting to the Information and Privacy Commissioner. When you see the acronym IPC, that stands for Information and Privacy Commissioner of Ontario. That was introduced in 2019. Now, some of you have never made a privacy breach report to the Privacy Commissioner. Those are due every February, late February, early March, every year, only if you are the custodian of the records and only if you've had certain kinds of breaches. I'll go into the details later in this webinar, but that happened. Those statistical reports were introduced in 2019. We also saw an increase in fines in 2020. So fines now for breaching the act intentionally can be up to $200,000 for an individual and up to $1 million for a corporation. So if you run a practice that is a corporate entity, you could be subject to up to $1 million in fines. There have been no corporate fines issued to date. There have been 5 people successfully prosecuted for privacy breaches relating to snooping. The highest amount of fine was $25,000 against a student social worker in a family health team who looked at the records of 139 patients that she was not providing care to, and she knew those individuals in the community. So she was fined $25,000. That was a personal fine to her. But those fines can be now up to $200,000 for an individual, up to $1 million for a corporation, and there can now be jail time for serious privacy breaches. That has never come to pass in the last 3 years, but that could be the case. Excuse me. There's also, as I mentioned, interoperability standards that you have to follow. And those came into effect in 2021. And there are these approved virtual visit vendor platforms that Ontario Health has verified and validated, lots of V's, on their website. Excuse me. So if you are going to introduce new tech for connecting with patients, you want to make sure that those technologies are approved on the list. There's also some new auditing requirements that we expect to come into force sometime this year. The government has not released the expectations for auditing, but the expectation from the Privacy Commissioner is that all health information custodians are logging, monitoring, and auditing activities within your health record. In particular, if you have other people, other staff, students, volunteers, locums in your health record, that you are auditing their activities in those health records. They're also changing standards for giving clients access to their own records. So if you have an electronic health record, there is an expectation that you would be able to give an electronic format of that record to your client. We're waiting to see the details of exactly what formats you'll have to make available to your clients. But the idea is that because clients have a right of access to their records, they should be able to get some version of their record that is easily viewed and used by them. So that's one of the expectations that we've seen changing in the government standards. There's also changing standards to acknowledge the roles of Ontario Health Teams. So when you see the acronym OHT, that stands for Ontario Health Team, these are groups that have gathered together, usually in geographic regions, to support continuity of care in the region. And some of you may be participating in Ontario Health Teams. If so, it's just important for you to know that our privacy rules are now starting to acknowledge the rules of Ontario health teams. We expect sometime this year, 2023, that there may be some changes to our privacy law to acknowledge that there can be sharing of identifiable information within an Ontario health team for things like population health analysis. So as communities are coming together, looking at the care journey of individuals, there is an acknowledgement that it would be beneficial to the public, it would be beneficial to individual clients, that information is shared within the healthcare providers of a community to map or track or predict where people are receiving services. So just keep your eyes open. You may see some information about Ontario health teams and new ways in which information may be shared within a community. And then finally, in the last couple of years, specifically in response to the pandemic and the radical impact that has had in our healthcare system, we've seen some changing standards from our Information and Privacy Commissioner about virtual care, about working from home, and about secure destruction of health records. So that was my first topic about the roles of health information custodian. So again, if you are a custodian, you are responsible to protect the personal health information you hold. If you are employed by a health information custodian, it is your obligation to follow any rules that have been shared with you by the custodian. Our second topic is to talk about the circle of care, and there's so much mythology about the circle of care, so I really want to demystify what this means. It's really important when you are practicing in the health sector to understand what is the circle of care and where does it end. So really, the circle of care is one end of a continuum with a lockbox or a consent directive. So the circle of care is when you believe that your client wants their information shared with other healthcare providers for the purpose of giving them healthcare. So it's really a greasing of the wheels. It just makes it easier. Our law acknowledges that it's important for healthcare practitioners to have easy access to information in order to provide healthcare. So that's the circle of care. On the other side of the spectrum is a lockbox, or what we're now calling consent directives. So a lockbox or a consent directive is when a client says, no, thank you, I don't want information shared with other healthcare providers. I don't want my information to be shared for continuity of care. So that is the opposite of the circle of care, is when a client does not want their information shared for a healthcare purpose. So the circle of care, to be able to assume the implied consent of your client to share information, two things have to be present. There's a who and a why. So the circle of care involves sharing information, or from your perspective, disclosing information to another direct healthcare provider. And two, the why is for the purpose of providing healthcare. So to be able to assume that you can share information with someone else in the circle of care, that someone else has to be a direct healthcare provider, and you have to be sharing it only for the purpose of providing healthcare. And this is something I just want to distinguish for you. As healthcare providers, all the activities you do, you think about as part of delivering healthcare services, but the law differentiates those. So the why you might be wanting to share could be for quality purposes, or it might be for teaching purposes, or program planning, or population health, or for risk management, or with respect to a proceeding, or some other administrative purpose. That is not the circle of care. To rely on implied consent to share information with someone else, the why has to be relating to providing actual healthcare services. So that those two components have to be present to have the circle of care. So I just want to invite you into a thought process here. Have a look at this list and think about who could be in the circle of care. So we have a school, a hospital, insurance company, client's sister, a landlord, the police, a primary care team, workplace safety and insurance board, and Children's Aid Society. So have a look at that list, and who do you think can be in the circle of care? Well, the answer is the hospital and the primary care team. Those are direct healthcare providers, so they can be in the circle of care. So we can assume implied consent to share information with hospitals and primary care teams. We cannot share information with a school, client sister, landlord, police, workplace safety and insurance board, Children's Aid Society, or an insurance company relying on implied consent, because there is no provision in our law to assume implied consent for those groups. So who can be in the circle of care? The who part of that two-part test for the circle of care are the usual suspects of people providing healthcare. And this list will be familiar to you because it's almost all of the groups and individuals who are health information custodians. So you are allowed to assume that you have your client's consent to share information throughout the healthcare sector to traditional healthcare partners. And you are also in the circle of care. Regulated health professionals, if you have an independent practice or a group practice, you are your own custodian. You can be in the circle of care, and information can come to you from other groups. They can assume that they have the implied consent of their clients with whom you share care to share information with you, relying on implied consent. So you are also in the circle of care. So as long as they're sharing information for you to do care, not those secondary purposes of proceedings or risk management or quality, but for you to do healthcare, those other agencies can assume that they can share information with you. So that is what the circle of care is. Who's not in the circle of care? All those other groups I mentioned. This does not mean we don't share information with these groups. Of course we do. It's just we cannot assume implied consent. So to share information with anyone on this list, insurance companies, employers, family members, teachers in schools, landlords, Children's Aid, police, Health Canada, the Ministry of Health, the Ministry of Long-Term Care, prayer and spiritual healers and leaders, we need express consent, or you have to be permitted by law to share with them, or what mostly you rely on, there will be circumstances where you are required by law to share. For example, a mandatory report to Children's Aid would override privacy expectations, but you cannot assume these groups are never in the circle of care. So how do you know that you can rely on implied consent? You're allowed to assume it. So the idea in our Ontario health sector context is that we should be sharing information with other healthcare providers so that there is a really good experience of clients through the system, that they are experiencing continuity of care. But if you have a sense, or if your client has told you not to share, then you cannot share. And if you believe that you should check with them, there's nothing wrong with you asking the client, because the circle of care is not no consent. If you know that the client does not want you to share information with other healthcare providers, then you can't share. And in order for you to share, you would have to go and ask the client, and you would get that either in a verbal consent, which you would document, or a written consent from the client. So the circle of care is the underpinning for all the work that's being done by Ontario health teams. And these Ontario health teams were created under the Connecting Care Act, which came out in 2019. So you may have heard about these Ontario health teams. They are moving us into this new world order where healthcare providers are going to share personal health information within a geographic region. But there is an expectation that clients and the public are told that information is going to be shared between healthcare providers in that region. So that might be done in posters, in brochures, and in community notices. And if you are a signatory as a partner to an Ontario Health team, you may be invited to help explain the circle of care, to help have posters up or help to share information about, electronic systems and how information is shared. The idea is, the future state is that when we have mature Ontario Health teams, there's going to be integrated health records. We all hear this, amazing future state of there being one client, one record. That is part of the vision of Ontario Health teams, is that we will have integrated health records and that there will be client portals so that clients can see their health journey and they can have access to information relating to their health journey so that they can be engaged in their health services, they can be knowledgeable about their health status, their conditions, their opportunities through portals. So that's kind of the future state vision for Ontario Health teams. Okay, moving right along, our third topic has to do with social media. So I was asked to give a little bit of thought to what's going on for regulated health professionals using social media. And some of you may have integrated social media into your practice. You may have a vibrant Instagram account. You may be using Twitter. Just, from a privacy perspective, it's really important that you are crystal clear about not sharing identifiable client information on any social media platform. I have seen, especially in the pandemic, clinicians, regulated health professionals trying to reach out to the public and having a dialogue about positions about vaccination, positions about the pandemic. But this has been going on for decades. There have been, with the introduction of social media, there is the intersection of regulation, privacy, and practice, and marketing, and engagement with clients that come to points of friction. So one of the main messages that I would convey to all of you is that you have to be really vigilant not to share client information on any social media platform. And when you are trying to tell a story, because stories are the best way of impacting and changing hearts and minds, you have to be really careful that you really have truly de-identified a client circumstance. And sometimes when I'm watching what people are putting out on social media, I cringe a little bit thinking, you know what, that person's family would know that you're talking about that client. That client would know that you're talking about them. It is best if you are going to be communicating on social media for you to use composite stories, like, let me tell you about the typical client that I see, or let me share with you my experience of serving these kinds of communities or providing these kinds of services. And using a composite story is still compelling and effective, and you don't have the same risk of inadvertently sharing information about clients. The Privacy Commissioner of Ontario has reinforced many times that merely, not saying someone's name does not de-identify personal health information. If information that you share is identifiable, then you can be judged for having shared information without consent. Also, if what you share could be coupled with any other information, you think you've de-identified it, but then it's linked to something else that reconstitutes it and it becomes client identifying information, you can also come under scrutiny for privacy breaches. So if you have the consent of clients, that works. You can share their client stories on social media platforms. You still want to be obviously respectful, but mostly the issue is you can really reduce your overall risk if you use composite stories, or you just take a bunch of different client experiences, you put them together, you use a little bit of this and a little bit of that, and you still have the impact that you want to have on your social media platform. There are some cautionary tales that have been going with respect to social media. So there was the case of Dr. Six, who is a cosmetic surgeon in Toronto. Back in 2021, he received a 6-month license suspension from the College of Physicians and Surgeons of Ontario. Now, his case was a mix. It had to do with video surveillance that he had in his cosmetic surgery practice. So they had, I think it was 26 cameras up in the practice in all areas of the surgical suites and in the waiting rooms all over. And that was deemed by the Privacy Commissioner to be excessive. So he wasn't allowed to have that many cameras up, and also not allowed to have them running all the time. So there was a video surveillance component to this case, and the College of Physicians and Surgeons agreed that the video surveillance was heavy-handed. The college was concerned about his use of social media. And so he had quite a robust social media platform, and was using, it is alleged, and when you look at the case that went before the college and what the college concluded, there was a conclusion that he failed to get sufficient consent from his patients for before and after photos, before and after stories, and for live media streaming of procedures that he was performing. So there is a privacy component to this case. There's a consent to treatment component to this case. There is a consent for media release for this case. So I guess the message for all of you is to be careful when you are sharing stories in order to improve your practice, improve your reputation. You want to make sure that you have really clean, clear consent from your clients to include anything to do with them in your social media. There are some other social media cautionary tales I'll share. They're not exactly related to privacy, but I think they're instructive, because there's really right now, there's some key cases coming out right now about regulated health professionals and social media. So it's like time is of the essence, but there's some historic ones too that kind of lay the groundwork for what is appropriate use of social media if you're a regulated health professional. So back in 2012, there was a case of a psychologist who was giving advice on a podcast, and she was promoting a concept, was called defooing, which was found not to be in alignment with the College of Psychologists of Ontario standards for what the college was recommending. So she was online, she was talking about this practice. She didn't think she was engaged in the practice of psychology. She thought she was doing a podcast, and the college was critical of her messages. And there was a question whether she was engaging in clinical relationships when she was online. So social media, broadly speaking, could include podcasts. That certainly is a marketing effort. And I guess what the comment for all of you is to be thoughtful anytime you are communicating in a public forum. If you want to utilize the title of psychologist, or any of you who have restricted titles of midwife or physiotherapist, other kinds of disciplines, your college may take a position that what you are saying publicly when you utilize that title needs to be reflective of what the college would expect you to deliver in your clinical encounters. So we are seeing some cases come up like this. There was a case, sorry, it's a little bit fuzzy here, but there was a case in 2016 about a nurse who was concerned about care that had been delivered to her grandfather. And she went online on Facebook and had a rant. And, as a family member to someone receiving healthcare services, everybody's allowed to rant online. The problem for her regulatory college was that she mentioned that she was an RN. So she stated, as an RN and a healthcare advocate myself, I have to speak up. So the college said she brought the profession into her rant, and she failed to take the normal college step-by-step approach to dealing with conflict with another healthcare organization. Ultimately, so her college fined her. There was a disciplinary consequence. That was overturned 4 years later by the Court of Appeal in Saskatchewan. But nobody wants to have to go through that kind of turmoil and that kind of conflict with your college. So I'm bringing this up as a cautionary tale. There are some changing standards about what constitutes freedom of expression, and that might be really important to you. So you get to choose your battles here. But I just want to bring to your attention that regulatory colleges do take what we put online seriously. And the latest, which you may have been hearing about in social media right now, is Dr. Jordan Peterson, who is a registered psychologist in Ontario. He is an online personality. He has a lot of different kinds of podcasts and courses, and he's an influencer. And the College of Psychologists of Ontario has told him that he has to complete social media training because they are concerned that some of his tweets from his Twitter account lacked professionalism and are bringing the profession of psychology into disrepute. And this, I believe, relates to comments that he has had on gender, masculinity, femininity, and gender identity. But I haven't looked into it totally. I guess the takeaway here is, again, anything that you are doing online, if you want to use your professional title, just beware that your regulatory college may be interested in what you are putting out on social media. And from a privacy perspective, you always have to make sure that you're not including patient stories without consent. Okay, moving right along into our fourth topic of this webinar, we have to talk about privacy and kids. And I was asked and told that some of you are, struggling on a day-to-day basis with who gets to make decisions about the information relating to services delivered to children, and what happens if we have a dispute or a duel between parents of a person receiving services. So our number one message when we're talking about privacy in children is that there is no magic age when children automatically become able to make their own privacy decisions. Privacy relates to capacity. And so if you have a client who is capable of making their own decisions at any age, they make their own decisions. And how do you know if your client is capable? You, as a regulated health professional, have to make a determination. Now, we presume that all clients are capable, but if we are suspicious that someone might not be capable, we apply the test for capacity. And this is very relevant for those of you who are treating individuals between the ages of 10 and 16. Many times, most of the time, as children develop, they're going to be capable of making decisions after the age of 16, sometimes after the age of 18. And most of the time, we don't have children making their own treatment decisions under the age of 10. But between the ages of 10 and 15 or 16, there can be variations in individuals' intellectual, developmental, and maturity capabilities. So there is a legal test for capacity, and the legal test for capacity is the same for treatment, for counseling, and for making privacy decisions. So when you are suspicious that someone may not be capable, then they have to pass a two-part test. It's an ability test. So the test is, does the person have the ability to understand the information about the privacy decision? And number two, does the person have the ability to understand the reasonably foreseeable consequences of saying yes or no to the privacy decision? So it's really an intellectual test, it's a maturity test, it's a developmental test. Does the person have the ability to understand context? And so that is what you are assessing, and whoever is providing the service is determining capacity. So who can make decisions for children depends. Privacy decisions for children, if the child is capable, they can make their own privacy decisions. If the child is incapable, they will need a substitute decision maker. If the child is deceased, then if there was a will, it's the person who was named in the will. And for children, they're not going to have a will. If not, it's the person who has taken over administration of the estate. So for children, that would be usually their parents, whoever is dealing with the body, whoever is making any kind of religious service arrangements or any kind of funeral arrangements. So it's the person who is taking over administration of the deceased person's estate. So when it comes to kids, there's another thing for you to think about, and this impacts those dueling situations. So just focus here, because you have to listen to this part carefully. If you have a client who is under the age of 16 and they're capable, they can make their own decisions, but so too can their parents make privacy decisions about any information, as long as the child did not make their own treatment or counseling decisions relating to that information. If the child was making their own treatment and counseling decisions, any information relating to those services, the parent cannot have. But anything the child didn't consent to on their own, the parent can make privacy decisions about. Except a capable child can overrule their parents, and they can say, a capable child can say, I don't want my parents making decisions about my information. So here's just a little cheat sheet reminder of who can make decisions for kids and for any service recipient. Excuse me. So let's just go through a couple of quizzes to test out this information. So what if you had a 13-year-old who is capable of making their own decisions? The parents want historic records from when the client was 9 and had services with parental consent. So you can have the child consent to the release of those records if the child's capable, and in this scenario, the 13-year-old is. But the parents could also consent to the release of this information because it related to services when the child was not making their own decisions. Even though the child is capable now, the parents can also release that information. As soon as the child turned 16, the parents could not make decisions about this. What if you had an 8-year-old child who was incapable of making their own decisions and the parents want a copy of the health record to get a second opinion? Then you would have to give it to the parents because the child's not capable. You're not asking the child for permission. You would have to talk to the parents, who would be the child's substitute decision maker. What if you had a 15-year-old who was receiving services on their own, and the parents want a copy of the record to send to an insurance company? In this case, even though the child is under the age of 16, the child was making their own decisions for service, so therefore they control all the information and records about that service. So the child could consent, but the parents could not consent. With respect to parental disputes and dueling families of all different makeup and all different descriptions, we have seen cases come forward to the Privacy Commissioner dealing with privacy disputes. When we're talking about a capable child, the capable child will decide who's going to have information. If they want parent A and parent B to have information, both of them can. If they only want one parent to have information, that capable child can decide. The real struggle comes for you when you have an incapable client and there are dueling substitute decision makers. So there are parents who disagree, or you have an adult and the adult client is incapable, and there are, there are siblings who are disagreeing, or there are parents who disagree. When that happens, the substitute decision makers have to get along and they have to decide what they're going to do. They each have power to decide. So anyone who's in the category of being a substitute decision maker, they all have decision-making authority unless that right has been removed from them. So when we look for a substitute decision maker, there is a legal list, and it comes under our health privacy law. For the most part with children, you're not going to see a guardian of the person. You can't see an attorney for personal care because they can't complete that. And it's highly unlikely you're going to see a personal representative appointed by the Consent Capacity Board. That could happen, but it's rare. What you're mostly going to be looking at for is who's the automatic family substitute decision maker. So you'll see on the right side this list of automatic folk who pop up to be substitute decision makers. With a child, you're not going to have a spouse or partner, but you're going to start at number 5, parents. And parent is defined as a custodial parent. So if there's a difference between parents, that one has custody and one has access rights only, the custodial parent outranks the access rights only parent. If parents' rights have been removed and a child is living in the care and custody of Children's Aid, then Children's Aid Society would be the substitute decision maker. Otherwise, if parents aren't available, you're going to keep going down the list. A brother or sister or any other relative can be a substitute decision maker. And if there aren't any relatives, then you would go to the public guardian and trustee to make decisions. If you have dueling parents, if there's been a separation or divorce, you assume joint custody unless you have been shown otherwise. And how would you be shown otherwise? Through a court order or a separation agreement that has been approved by the courts. There have been some decisions that have come before the Privacy Commissioner, as I mentioned. So this is one of the cases. Parent A came to a healthcare provider and said, I'd like to have a copy of my children's records. Unfortunately for him, parent B proactively came to the organization and said, do not share information with parent A. And when that happens, then the organization or you as a healthcare provider cannot share information because now you have conflicting instructions from the joint substitute decision makers. This is stupid. Mostly you can cajole parents to kind of get along because you can imagine the next step will be that parent A says, fine, you can't share any information with parent B. And this just becomes ridiculous. So, but the Privacy Commissioner said that if there are 2 substitute decision maker parents and one parent objects, then you cannot give information to the other parent. And just to answer a question that I think you might have, the Commissioner went further to talk about, do we have to ask every single time? And the answer is no. So if you know that there are 2 parents who have custody and one parent comes forward and the child is not capable, so the parents are acting as substitute decision makers, and one parent asks for a copy of the record, you do not have to proactively ask if the other parent would agree or disagree. You can just give it to the substitute decision maker parent. The only time this becomes complicated is if you proactively know that the other parent disagrees. You might need to get advice in these cases. You might call your professional association, you might call a lawyer to kind of help you work through these circumstances. They get to be a bit complicated. Just so also that you know, there is changing law about who constitutes a part of a family. And so in 2021, a BC judge ordered that a second mother in a polyamorous trio was declared to be a third parent to a child. So just be mindful that we respect people's family configurations, especially if they are represented by legal documentation. Okay, just to wrap up our webinar, I wanted to go over how do you know what is a privacy breach? How do you identify a privacy breach? So if you are the health information custodian, you are responsible, again, for the safeguarding of the health information you hold about your clients. If you're an agent, you still have to safeguard information, but you would have to tell the custodian if you believe that you participated in a breach or you've witnessed a breach. So you do have to protect client information and client records from loss, theft, unauthorized use and disclosure, unauthorized modification or destruction. Those words mean a privacy breach. And if there is a privacy breach, you have to notify impacted clients and you have to notify the Information and Privacy Commissioner in certain circumstances. You know, sometimes we think of a privacy breach as super narrow. There are many different ways you could have a privacy breach. That definition, as I mentioned, loss, theft, unauthorized use and disclosure, modification and destruction, is really broad. So think about it in these 9 categories. You could have snooping, so your staff looking at records when they shouldn't be. You could be hit by ransomware or an external attack or a theft of your devices. You could lose an unencrypted laptop that has client information on it. There could be inappropriate sharing of information within your team. So people who shouldn't be having information, it's shared with them. You could have misdirected faxes, emails, mail. You could have a situation where health information was posted or made publicly available. That has happened recently. There could be vendor mismanagement. So we've had some cases where health practitioners have hired a shredding company, but they don't shred the records. They sell it for scrap paper, and then those health records, pop up in other environments. So that would be a privacy breach. You can have sharing of information with third parties. So sharing information with family members when that shouldn't happen. Sharing information with the media when that shouldn't happen. Or insecure disposal. So again, not shredding, leaving information or putting it into recycling by accident, that kind of thing. So a broad range of what is a privacy breach. Our Privacy Commissioner does have guidance for you on what to do when there is a privacy breach. So looking at the Privacy Commissioner's resources on what to do when faced with a privacy breach is a good resource for you. The Commissioner recommends that you undertake 4 steps when there's a breach. You implement your protocol, you contain the breach, you stop it from getting worse, you notify the people impacted by the breach, you investigate, and you stop it from happening again in the future. Again, there are some resources by the Privacy Commissioner. There are 2 kinds of reports to the Commissioner, and I think a lot of regulated professionals don't know this, so I want to bring this to your attention. There's an annual statistical report, and then there's reporting of breaches in the moment. For the annual statistical report, that is due in late February every year, only if you've had any kind of breach in any of these 5 categories. If you've had health information stolen, personal health information was lost, you've had personal health information used without authority, you've had personal health information disclosed without authority, or personal health information was collected without authority in an electronic health record. we're just about to get the 2022 statistics. Those usually come out in June every year. I can share with you the 2021 statistics for now. We had 11,000 privacy breaches reported by all health information custodians across the province in 2021. 7% of those came from healthcare practitioner practices, solo or group practices. Of those breaches, there was a small amount that were theft of records, 200 cases of lost records, some unauthorized use, but the vast majority of privacy breaches relate to unauthorized disclosure, that's sharing it outside of the practice. And you'll see that most of those relate to faxes. So our privacy commissioner is really coming down on faxes, really recommending that clinicians move into an environment of secure transfer of information from the practitioner to the client, but also between practitioners. So end-to-end secure transfer of information. There are 7, so those were the annual statistical reports. If you have a privacy breach, there are certain things that you do have to report to the commissioner in the moment. If you have cases of snooping, if information has been stolen, these are health records stolen. If someone has received health records and they're threatening to go public or share information with the public, you have to report that to the commissioner in the moment. If you have discovered a pattern of breaches, you have to report that. There is an obligation if you terminate or discipline one of your staff for reasons of a privacy breach, that has to be reported to the commissioner. And if there are regulated health professionals, that also has to be reported to the college. And then there's a bucket of anything else that is significant. So if you have a lot of clients impacted, highly sensitive information impacted, a lot of custodians impacted, that would also require an in-the-moment report to the commissioner. So that brings us to the end of our whirlwind tour of what's going on in health privacy. If you need more support about privacy, I do a free Ask Me Anything About Health Privacy the first Wednesday of every month. I don't do it in the summer, but otherwise the first Wednesday of the month. As part of this registration with your college, you can get a copy of my summary of all the health privacy decisions of the privacy commissioner. If you want to hear and see what do privacy breaches sound like and look like, and what's the outcome, how do we respond to those properly, I've provided you with a summary. But also I ask that you look at your college guidelines on privacy, on telehealth, on record keeping, on social media. Keep up to date with what your college is giving you as the scenarios and guidance in these areas. And also, our Information and Privacy Commissioner of Ontario has resources for you for the health sector. Thank you so much for your time. It's been a joy to be with you, and I look forward to being with you again.